All right, we're going to get started. All those present vote aye on electronic voting board. Hit the staff there.
You have a quorum, Mr. Chair.
All right, we're gonna go by the sign-up sheet. Delegate Freitas, I think you might have an amendment to yours that
That's
we
correct,
need to
Mr.
look
Chairman.
at. Oh, yeah.
I'll just briefly explain the amendment.
Go right ahead.
So essentially what the bill seeks to do here is it allows bed and breakfast to be able to set up things like wine tours and whatnot for their guests, which currently is not permitted unless they have a special brokerage license to do just that. So we're exempting them from that. One of the requests was that we specified that when they set up these wine tours or brewery tours or whatever it is, that it's only for the guests of the bed and breakfast. I thought that was a reasonable amendment, and so that's how the amendment changes the underlying bill, Mr. Chairman.
All right. Chrissy, you want to just report what the amendment so we can adopt it?
Thank you, Mr. Chairman. On line 21 of the engrossed, after establishments, insert comma, provided that their broker service is provided only to guests of such bed and breakfast establishment. And then the following three amendments are technical, and in each, I'll just read them. It's easier that way. On line 22 of the engrossed, after any establishment, strike little I, insert A. On line 23, after bedrooms, strike little 2, insert B. And on line 24, after and, strike little 3, insert C.
All right, is there a motion on the amendments? These amendments would, motion and second on the amendments. You want to briefly speak to the bill?
Sure, Mr. Chairman. Again, the goal here is to ensure that when someone stays at a bed and breakfast, if the bed and breakfast wants to set up wine tours so that they can get on a bus and go around and visit various wineries or historical sites, that they'd now be able to do so, which currently they would not unless they had a special brokerage license to do that. So it's just a simple exemption with the added specification of the amendment that it's only for the guests of the bed and breakfast.
Right. All right, any one in the audience like to speak to the bill?
Mr. Chairman, Nicole Brenner with Reed Smith on behalf of Uber Technologies. Just want to thank the patron for the amendment.
All right. Anyone else? Anyone in opposition? All right. Seeing none, Senator Cosgrove.
Thank you. Delegate, is there any insurance requirement on these folks as far as having to carry the same amount of insurance as any brokered delivery service would have to do?
Mr. Chairman, I would say that I don't think there's any additional insurance for them to, again, the goal here is not for them to set up their own bus service and shepherd people across the area. It's mainly for them to be able to contract with a bus service so that they can make that available to their guests. Because right now, one of the things that was interesting was if you stayed at a bed and breakfast and they wanted to call up a local area that does wine tours and get that established for you, they couldn't do that unless they were a travel agency. And so that's what we're going after with this. It's not to set up a separate bus service.
All right. Any other questions? We did vote on. All right. All in favor of the amendment, vote or say aye. All opposed? All right. Now we have the bill before us as amended. It's motion on the amended bill. Is there a second? Yes. All vote aye on the electronic voting board.
Twelve ayes, 0 nays.
Bill reports 12-0.
Thank you, Mr. Chairman, members of the committee.
Delegate LaRocque.
Thank you, Mr. Chairman, members of the committee. This is a very simple bill. Living in Northern Virginia, being involved in transportation, I've come to realize that the organizations that coordinate and budget for transportation spending in that area, I've named 4 of them: Northern Virginia Transportation Authority, Northern Virginia Transportation Commission, Virginia Railway Express, and Commonwealth Transportation Board. Again, coordinate numerous projects, and millions and millions of dollars are spent on these projects. So the proposal is that although currently they each have several meetings during the year during which they present to the public their planning and prioritization of projects. There is not a single time when all of them meet and co-present. So the proposition is here, for the sake of greater transparency and accountability, we're asking that at least one of those meetings, not necessarily a new meeting, not adding any to their load, but for them to coordinate one of those meetings so that they are co-presenting at the same time and place. And that, Mr. Chairman, members of the committee, is the proposal.
All right. Any questions of the patron? All right. Anyone in the audience like to speak in favor? Anyone in the audience opposed? All right. Senator Cosgrove.
I'm sorry to ask again, but isn't this going to be a logistics nightmare, getting all of those groups together in one spot? And who's going to pay for it? And how's it going to be advertised? And all those logistical questions.
Good question. Mr. Chairman, in response, I would say that there should be no additional expense because, again, if they're required to have 6 meetings, we're just asking that one of those 6 meetings would be done in a time and place that coincided. Logistically, now, well, I'll give you an example. Recently, 2 of these different agencies held a public hearing on the same night, so it becomes logistically impossible for someone that's interested in both of the projects that are being presented by both of those organizations to participate in both of the meetings. So this may present some logistical challenges for these entities, but it really is trying to kind of, at least in this one case, favor the consumer, the resident, the people who are being impacted by these projects, at least for one of these meetings. So challenges, yes, but hopefully convenience for the general public.
All right. Any other questions? Hearing none, is there a motion on the bill? Move to report. It's been moved and seconded. We report House Bill 1285. All in favor, vote aye on electronic voting board.
Thank you, Mr. Chairman, members of the committee.
11 ayes, 1 nay.
All right, your bill reports 11-1. Delegate Robinson. Delegate Murphy. Delegate Collins.
Thank you, Mr. Chairman. Ladies and gentlemen, HB 236 is a fairly simple bill. Currently, under current law enforcement can pull somebody over for an expired registration but cannot write a parking ticket for it unless that has been authorized via town charter. This does not create a new parking ticket presumption. It just simply adds that if they have that authority, they can write a parking ticket for expired registration for a vehicle that is parked on a highway, meaning a VDOT-controlled road. So it's not dealing with people who have a car in their driveway or something along those lines. They'd have to be parked on an actual highway designated by the Commonwealth of Virginia.
All right. Any questions of the patron? Anyone in the audience like to speak in favor? Anyone in the audience in opposition? Hearing none. Okay. All right. There's a motion and a second that we report the bill. All in favor, vote aye on electronic voting board. All right.
13 ayes, 0 nays.
Bill is reported. Thank you.
Mr.
Delegate Adams.
Good afternoon, Mr.
Good
Chairman.
afternoon.
Members of the committee. Mr. Chair, HB 712 makes the naming rights of highways, bridges, and other transportation entities consistent with the current practice by the board and removes allowance of naming by private entities for pay from the code. Further, it grandfathers transportation entities already named.
All right. So basically just a cleanup bill on how we're naming these highways and bridges, right?
Yes, sir.
All right. Anyone in the audience like to speak in favor of the bill? Anyone in opposition? You want to speak to it, VDOT?
Mr. Chairman, Emmett Helsel is the department. We strongly support the bill.
Okay. Anyone in the audience in opposition? All right. Anyone on the, all right.
Mr. Chairman, can I have a question
Senator-
before it gets
Senator
reported?
Suderline.
What what's the issue that's trying to be addressed here? Is there a specific instance that brought this bill about?
Yes, sir. Mr. Chairman, essentially in 2012, the rules were changed such that private corporations could name transportation entities after living persons. Since that time, it has hardly ever, if ever, been done. And the department wants to restore the dignity to the naming process that it once held, since it's not being done, and therefore would like to change the code back.
All right, any other questions?
Yes, Mr.
Yeah,
Chairman.
Senator Suderline.
So I remember, at least in the last 3 years, during the brief time I've been on this committee, the General Assembly named a transportation project in the eastern part of the state after a living member of law enforcement. So if this bill were enacted, would that not be permissible? Is that correct?
It essentially removes the ability to, well, the General Assembly can name
Yeah, we can still
anything they
do it.
want, but it's for entities that would pay to have a section of a highway or any part of a transportation entity after a living person, or just for pay.
And I think my final question, Mr. Chairman.
Senator Suderline.
So, so we would still be able to act as we wanted here, but I guess what wouldn't be able to happen is like the Geico rest areas that currently exist. That wouldn't be able to happen in the future?
Mr. Chairman, as I understand it, sponsorships of things like rest areas are still allowable. It's really, but it's through a different part of the code, as I understand it.
We're going to phone a friend for you here.
Yes, thank you.
Emmett, let me ask you this question. If a locality wanted to name a bridge after a mayor, could they do that if this bill passed and he's living? One of the reasons we took that away is so it wouldn't be a constant campaign sign on the bridge, so the mayor would get elected every year.
Mr. Chairman, if I may, can I loop back quickly to
Sure.
Senator Suderline's question and add to what Delegate Adams was saying? Essentially, one of the things we're trying to correct here too, sir, is that the Federal Highway Administration changed some of their programmatic arrangements with sponsorship and these naming programs subsequent to that legislation in 2012, and they removed that opportunity from us. So what we were trying to do with the naming rights is no longer in vogue from their perspective. It became too much akin to advertisement in their view. So this revisitation of the law, basically putting it back in its original form for the most part, is simply to acknowledge that. To the chairman's question, I think if I understand it correctly, the naming of a living person would still have to be done by the General Assembly.
Mr. Chair.
Senator McClellan.
Thank you, Mr. Chair. If you look on line 13 of the bill, this code section only deals with the authority that the board, and I assume that's the Commonwealth Transportation Board, has. So if the Commonwealth of Virginia or if a local government wanted to name a street or a bridge after anyone living or dead, that's dealt with for localities, a separate section of the code. My understanding is, I think in most cases, they have to come to the General Assembly for permission if they're a county, but cities and towns would be able to do that under their own authority. And so this is just dealing with what the board itself can do subject to federal regulations, and it's putting this in line with federal regulations as they've changed.
Thank you, Senator. I believe that's correct. Thank you.
All right, any other questions of the patron? All right, anyone else on the committee have any comments?
Move to report.
There's a motion and a second that we report House Bill 782. All will vote aye on electronic voting board. Or you can vote no.
13 ayes, 0 nays.
Thank you,
Bill
Mr. Chair.
reports 13-0. Delegate Yancey. We're working on something for you here real quick. Delegate Robinson. Yeah, all right, Delegate Murphy. Delegate Murphy.
Hello, Mr. Chairman. We have, which bill is it? 662,
American Legion Bridge.
American Legion Bridge, my very favorite bridge. What we did was we put in a bill to get, to move VDOT forward in beginning the initial design and assessment for remediating the American Legion Bridge. Certainly, once Maryland has decided to move, and we've been working on getting them to move forward on this issue, meeting with them, have written a letter to Governor Hogan, as well as to our own governor. We have a real traffic problem that is being caused by traffic pileup at the American Legion Bridge. It's literally like a parking lot. It's causing problems for our neighborhoods. And so we put this, this language in as a method to get them to move forward, hopefully soon.
So, Delegate, and maybe VDOT can answer this for me. We've seen no impact statement. This is just a ability to get VDOT and the other states to come together and work out a reasonable solution for the American Legion Bridge as it stands right now.
Yeah, and it will take time, and we acknowledge that, but we need to get the process started. So the language is really a kind of a push in that direction. It's really to get
So we
the
understand
project
what it's intended to do. We just want to make sure that we're not having to rush a bill upstairs because it's a revenue bill.
Well, we did put in a, you know, what do you call it?
A budget
Budget
amendment.
amendment, thank you. It's been a long day. And what it says is that the Department of Transportation should use the money that they already have, existing funds, for this. It doesn't ask, it just directs funds if needed. And we have been in conversations with them. I don't,
So VDOT, you're okay with, all right.
All right, Mr. Chairman, I have a question then.
Senator Cosgrove.
Thank you. This is more for VDOT instead of you, Delegate.
oh, thank you. It's you.
I guess the question is, I've had a lot of experience with building roadways within the city of Chesapeake or serving on House and Senate Transportation for the last 17 years. I've never seen a design for a bridge this substantial that wasn't going to cost a lot of money. Now, even just the initial design for the high-rise bridge in Chesapeake, which is not as substantial of a bridge as this, was over $5 million. So, and I don't mean to, and I don't want to hurt the bill or anything, but I just want to figure out how decisions like this are made. I mean, if all of a sudden Maryland says, okay, let's go, VDOT is going to have to expend a lot of resources to start the initial design on this bridge. Is that correct?
Mr. Chairman, Senator Cosgrove, I think one of the first things that would have to be done is liaison with the Maryland authorities. I think certainly subsequent to that, before design work is done, a significant effort would probably have to be done regarding an environmental impact statement. I couldn't even speak to what all the nuances are involved there. It would be, I think, a very comprehensive effort, similar to other projects that are being done in Northern Virginia, or have been done in Northern Virginia in the past. So I think that would be the leading effort, and we would have to do that in concert with the Maryland authorities and the Federal Highway Administration.
Mr. Chairman.
Senator Cosgrove.
I'm not really sure you answered my question. Maybe you didn't, I didn't quite get it. It says, the Department of Transportation, quote, department, or unparent, shall begin the initial design and related assessments for remediating the American Legion Bridge. Now, I'm just telling you, design for these bridges is complicated and it's expensive. So I guess my question is, and I'll leave it at this, I'm going to vote for your bill, but I'm just trying to get something straight. it's got to have a financial impact. So I'm just curious as to why that's not reflected here. If VDOT can absorb that great of an amount of money for initial design, then, okay, fine, but I'm just a little confused.
Mr. Chairman, Senator Cosgrove, I don't know I can speak to the exact numbers that are involved. I would acknowledge that there would be.
Excuse me, I'd like to hear my answer, please.
There would be a cost to do that work. An exact figure, I don't know that I have that.
All right, thanks.
Senator Favola.
Thank you. And I was just attempting to respond perhaps to Senator Cosgrove's comment. I guess the point of this bill is to sort of get the conversation moving with Maryland. There's no timeline on when the design would actually be prepared. And I can tell you, working closely with Delegate Murphy and others on this issue, we are at least one budget cycle away from having any substantial activity that would require money to be devoted to this effort. So that's why the language is in here. And we do have budget language, which also is intentional in the Senate budget and in the House budget.
All right.
Mr. Chair.
Delegate Murphy.
The purpose of the bill really is to make Maryland start moving. We wait for them and we wait for them. And so this is like trying to set a fire under their feet. We've been in conversations with their legislators. We've been in conversations with people in the governor's office. What we're trying to do here is show that we need for them to continue to move forward. The bridge itself, Mr. Chairman, is owned more by Maryland than it is by Virginia. I think that our claim to it is only about 21%. But if we can get this started, if this can be the push that they need to start moving forward on this, it would really help the people of the 34th District who sit in gridlock every single day and who have a lot of Maryland cars whipping through their neighborhoods.
All right. Any other? There's a motion to report. Is there? And second, all in favor, vote aye on electronic voting board.
Twelve ayes, 0 nays.
12. Bill reports 12-0. 13-0.
Thank you, Mr. Chairman.
Thank you. Delegate Cole, you don't have a bill. Okay, well, enjoy the committee. Delegate Robinson. Delegate Yancey, do you have Peace in the Valley yet? All right, well.
But we're almost at peace.
Let's work on, how about Delegate Bell? Is he?
Chairman, he's in presiding over the city criminal courts, I think, across the way.
Can somebody tell him to come over here? Well, we're just waiting on patrons now, so. Look, if you'd like to speak to the bill and take that chance, we'll. Delegate Robinson, let's.
Thank you, Mr. Chairman. Sorry about that. So this bill is House Bill 1464, and it has to do with auxiliary lighting on motorcycles. It's basically the same language that was here before on, that you saw, I guess, last year or 2 years ago.
A little different.
A little different? It's slightly different? And it just provides that motorcycles will be able to put red and green lights on the motorcycles on the sides for.
Oh, back up. It's red and amber.
Oh, excuse me, red and amber.
You
right?
might lose your bill if you
Yeah,
keep talking.
excuse me, red and amber, sorry. They have to be directed towards the ground. They can't be flashing. They can't be on the wheels, and they can't emit a beam of light greater than 25 candle powers per bulb.
So, talking to your supporters, I did ask if, understanding what the bill does, it allows the lights that illuminate up to 25 candle power lights underneath, pointing downward on the highway, not to go beyond 10 feet. It has to be amber or red. And the only thing, because we were talking yesterday how you could utilize these, can they be cut off, can they be used, are they on steadily all the time? And because there are a lot of other type of lighting mechanisms out there, I asked if you would be amenable to a friendly amendment that it would basically say that it would be designed for vehicular use, which I think they're okay with. So
Yes.
I would offer that
We're
amendment.
fine with that amendment?
As to be designed for vehicular use. Right. Designed for vehicular use, because there's no way that can be approved. It's not of the candlelight fire.
Superintendent's got nothing else to do with that.
You never get it on your motorcycle. So if you could report that amendment.
Thank you, Mr. Chairman. On line 28, insert Romanet 3, designed for vehicular use.
There's a motion on the amendment and a second. All in favor say aye. Aye. All opposed? All right. Anyone want to speak to the bill? Anyone in the audience? All right. Anyone in the audience like to speak in opposition?
Mr. Chairman, I move to report the amended bill.
Okay.
Mr. Chairman,
Senator Wexton.
with this amendment, do we know where the state police are on this?
Well, they're not okay. I'm going to assure you because of the candlelight hours, but that's the.
I have instructions from Senator Deeds to ask that question.
Mr. Chairman, Senator Wexton, state police has very great concerns with a lot of parts of this bill. This is something we asked for that would at least get us into a realm to where it is designed and would prevent somebody from sticking any type of light out there. But there are still great concerns with the bill as written. Thank you.
All right. There's a motion and a second that we report the bill. All in favor, vote aye on electronic voting board.
Twelve ayes, 1 nay.
12 ayes, 1 nay. Bill's reported.
Thank you. Sorry my tardiness, but I appreciate the votes.
All right. Delegate Yancey, we're just going to have to go.
Thank you, Mr. Chairman.
Delegate Bell.
No, even better.
Good afternoon, members. Mr. Chairman, members of the committee, I appreciate you getting into my bill. This is House Bill 505.
All right. Dealing with traffic signs for people with disabilities.
Yes, sir. So the bill is actually so short as to, if you read it, you'll see exactly what it does, but it would allow for the placement of signs for the deaf, blind, or any person with autism or intellectual or developmental disability as defined by a different code section. And that code section is for fairly severe disabilities upon request. There's a mother who's here with the specific issue, and if you would give her a minute or two, I think it would explain the
Sure.
basis of the bill.
Just one question before
Yes,
you
sir.
go. Are these signs going to be paid for by the
Yes.
state or by?
Yeah, now, it says that the VDOT will come up with the regs, so we don't have I didn't want to be
So you
too
don't know what the
specific.
impact of that would be?
No, but the current plan is these would in fact be VDOT signs, not, we can already do
Private,
signs on the side of the road
right.
kind of things.
All right. Let's hear from your, then we'll ask you.
Hi, my name's Jocelyn Helmbrecht, and I live in Charlottesville. I have a 16-year-old son with significant special needs, and one of his diagnoses is autism. A few months ago, I put a sign at the top of my mailbox that just read "Child with Autism Area," and one of my neighbors complained to the Homeowners Association. They told me I had to take the sign down, and after some back and forth, they said I could put the sign at the bottom of the mailbox, which no one would see. Wesley falls into the 50% of children with autism who wander. And one of the things that prompted me to put the sign up was that he had wandered out. When I turned my back just for a couple minutes, I found him standing in the middle of the road. We eventually, my neighbor backed down, but I had to threaten to hire a lawyer. And so I started thinking about other families who might not have the means to hire a lawyer or the ability to advocate for their child. So I did ask VDOT if, because in other states, they do have signs that they'll put up if the family requests that one be put up. And I was told that they didn't do that and that I could not do that because my road is under VDOT. So I approached Delegate Bell to hope that we might be able to change that to help families like mine. I never imagined what it'd be like to have a child with special needs till I had one, and I think a sign like this would really alleviate some of the challenges of taking care of our children and keeping them safe.
All right.
Thank you.
Thank you.
Mr. Chair.
Senator Wexton. I mean,
Yeah, the other
McClellan.
one. This is more a question for, first of all, I support the bill, so don't worry. But don't cities, can cities do this? Because I know there are several places I've seen in neighborhoods in Richmond where there is a sign already for deaf children. Is that just limited to cities that can do that? And I recognize that's not, that only includes deaf children, but to me, this seems like we're just doing the same thing, but on VDOT roads and expanding it to other vulnerable children. So we're not, I guess my question is, we're not really setting new precedent, because don't cities and towns already have the ability to do this on their roads?
They're the one, they pay for the construction and so forth, so they would have the authority within their council to do that. But if you live in a area where it's a state-maintained highway, it has to have authority by the General Assembly to place those signs.
Follow up, Mr.
Senator
Chair.
McClellan.
As I read the bill, it appears to me to be broad enough that if, in developing the regs, VDOT wanted to establish a fee to recover their costs, could they do that?
I think they could. Now, that raises separate issues about, I mean, can rich people get this and poor people can't? I mean, there's all sorts of things that come with that. But yeah, this just says they shall do regs to allow for the setting up of these signs. It's one reason the FIST didn't come back. They said without knowing what the rules would be, it's impossible to come up with what the FIST would be. The original version, I had one of these 8-page bills where we do everything and everything. We said this really is not actually a good idea to put all of that in the code.
Right, and I'm trying to help you. Again, my point
no,
is, to the extent anyone is worried about whether there's going to be a fiscal impact, I think the bill is broad enough that if VDOT felt the need to establish a cost-based fee, they could do that. But, and I mean, I guess I can speak to the bill if no one else has questions. But.
Well, let's, there's a couple more people in the queue, and then we'll let you speak. Senator Wexton.
Thank you, Mr. Chairman. I guess my questions for the patron, I'm just kind of curious about what you envision these regs are going to do. So do you envision that the regs are going to be about like what the signs are going to look like and where they're going to be placed, or will they be so comprehensive as to include things like how are they going to verify that, you know, someone has a diagnosis, and what happens when, for example, that child grows up and moves away, or the family moves, and you know, what kind of methodology do they have for deciding when the sign goes up and when it goes down?
So yes, And I don't mean that to be funny. I mean, the whole hope would be, and having taken a stab at this myself, there's a lot of ideas that go into what you just said. So how many signs? Is there a clumping of signs? Can you have too many signs? Is it one sign? How close to the road? What's it look like? How do you demonstrate that you have, because the term, that it's a legal term, but the definition of intellectual or developmental disability as defined by, you'll see that's a separate paragraph. It's not just somebody who's having some issues. It's somebody who's fairly profound. Then, of course, deaf, blind. The one that is not as so well defined as autism, that's the one that would have to probably have its own definition. And again, how these are paid for. I think all of that would be in the regs. I'm happy to bring the bill back next year, and then I think we would do just what we shouldn't do, which is make it hard to change, and we'd be arguing about, inflation-adjusted dollars and all the things we do when it's in the law. The problem right now is that they can't. It's not like it's hard. It's not like there's a high standard and I'm trying to lower it. Right now, you just can't do it. And so if you have a runner, if your autistic kid's a runner, I don't say too bad, but it's too bad. I mean, there's nothing you can do to get a sign out front to say, yeah, everybody, you have the kids at play. That's not really appropriate. You say when they grow up, of course, it's not even limited to children. For those of us with special needs kids, they're going to turn 18. They probably are still going to live with us. This may not be the best way to do it, and this committee might have a better idea on how to do this. But that's what brought this to my attention, and there's no hidden agenda here. That's what we're trying to do.
Senator Cosgrove.
Thank you, Delegate Bell. Thanks for bringing this forward. Ma'am, I'm sorry, I forgot your name.
Jocelyn
Oh, what's your last name?
Helmbrecht.
It's nice to meet you, Helmut. Look, I support your bill, okay? But the reason that the chairman and I were up here shaking our heads had nothing to do with your bill, but had everything to do with your homeowners association. And if anybody ever wonders why we get so angry at homeowners associations, because of stuff like this. You can put it on top of your mailbox? No, but you can put it on the bottom. Give me a break. Okay, I've had my social statement there, but now the fiscal question is, and I'm looking at the fiscal impact statement, and Delegate, it says here that VDOT will be required to develop regulations for posting such signs and pay for the installation and maintenance of the signs posted under the regulation. So I guess the question, not for you, but for VDOT would be here we go again. Where's the financial impact statement? Now, I understand it could be small, it could be large, but normally when we see something like this, it says indeterminate or whatever. And, Senate Finance has a chance to look at it. Now, I don't want this to go to Senate Finance. I want this bill to pass. But, I'd also like some consistency on what's coming out of VDOT as far as what costs what. And thank you for being here.
VDOT, you want to answer that?
That's not fair. I mean, he's not the one.
And I don't. If you wanted an amendment to make it clear the regs could include how to do that, that's fine too. I'm not trying to pass something downstream.
Mr. Chairman, Senator Cosgrove, there will be an impact. Can we estimate that? Probably not. It depends on how regulations want to look and how long it takes to develop them. I think the signs would probably be somewhat inconsequential because I don't see them popping up like, flowers all over the state. But there would be some impact.
All right.
I'm sorry, Mr.
Senator
Chairman.
Cosgrove.
If a speed limit sign is going to cost $1,500, I don't want to talk about inconsequential. Thank you.
Senator Favola.
I know there've been some excellent questions asked, but I do think that the regulatory process, because it has such extensive public comment periods associated with it, VDOT usually brings the stakeholders together before they issue even a proposed rule, and then, of course, there's more comment for a public, before it becomes final. I really like the idea of the bill, and if you're ready for a motion, I'm ready to make one.
All right, Senator McClellan.
Second.
Okay. There's a motion and a second on the bill to report. All in favor, vote aye on electronic voting board.
13 ayes, 0 nays.
13-0.
Chairman, I thank the committee. Thank you.
Now, Delegate Yancey. Mr. Chairman, you, as you can see, we never can predict how bills are going to go.
Understandable, Mr. Chairman.
We do have a substitute, however, that we discussed.
Yes, Mr. Chairman. I have a copy, but always happy to have more.
There is a motion and a second on the substitute. All in favor say aye. Aye. All opposed? All right.
Thank you, Mr. Chairman. And as I understand, I think working with Delegate DeStefano, I want to thank him for his concerns and certainly working on to efforts to ameliorate this bill accordingly. Mr. Chairman.
House now, I just wanted to point that out, not the lower house anymore, but I'm just messing with you, David. Keep
Appreciate
going.
that. And as long as you keep sending us Girl Scout cookies, we'll still keep asking your bills. But no quid pro quo. Mr. Chairman and members, House Bill 1323 is before you. This bill passed the House 100-0. The issue, the reason why it was brought before you is military vehicle owners have bought some of these utility vehicles, military utility vehicles, where they were getting some registration, where others could not. There was some confusion, and this is clarifying language that would allow these vehicles to be operated on the Commonwealth with an understanding that this is a privilege and therefore with the granting of the appropriate registration and privileges of utilizing these vehicles. So, Mr. Chairman, I'm going to walk you through and the members through the bill. I would first encourage members to go to page 7, line 175 through 178. And here you will see the definition of the military surplus motor vehicle that we are using for this language. In essence, it would be, in a commercial sense, a Humvee or a Jeep, but not a tank, not a half-track, not any type of military vehicle that would give any pause or concern. In my district, in the Newport News area, we have some owners who utilize World War II era Jeeps that often go into parades, so this type of language would help them there, or any type of utility vehicle like a perceived Humvee, but nothing that would have, say, twin 50 calibers on them or anything like that. I know, I'm Senator Cosgrove. I appreciate your concern, but nevertheless, we have to keep it on the up and up. With that noted, I would members to go to page 16 and look at paragraph E. And here, Mr. Chairman, this is just the appropriate designation for the type of license plate for these type of vehicles. If you go down lines 409 through 414, the three things that this covers: one, you have to own another type vehicle. This military utility vehicle cannot be your preferred vehicle going to and from work, for example. Secondly, that this recognizes the type of ownership. Third, how it's registered. And then fourth, that you have to get the license plate. And so with one of the amendments offered in the Senate suggestion was that you and I spoke about, Mr. Chairman. So the registration fee goes from a one-time fee of $50 now to a one-time fee of $100. Going forwards on lines 415 through 424 through the remainder of the page, a new language would be to strike 250 from the original bill at line 422 and now be 125 miles. And this is only for occasional pleasure driving, not to exceed those miles, so, which is already, that language is already in the code. And backtracking through that language of 415 through 424, that just simply states what you can and cannot do with this type of vehicle. And saying here again, this is just something for use, but not day-to-day use, not going to and from work or anything like that. If you go to the next page at paragraph C, 425 through 427, that language is pretty well self-explanatory. And then going down to 428 through 438, here the bill addresses what happens if you break the privilege of using the vehicle, that you're going to have this registration suspended. Going into paragraph D at 434 through 438, that if you violate this privilege, that you're going to be held responsible for it. And the way it's going to be happening is, first, you're going to be convicted of a Class 4 misdemeanor, which is no more fine, no more than $250. And then 436 through 438, you're going to lose the privilege of using this vehicle for 5 years. And then additional language, Mr. Chairman, as you know from the amendment offered, is that law enforcement may require any operator of one of the vehicles to provide the residence address of the ownership for the vehicle and the destination of the trip. So here again, using my district, Mr. Chairman, the Hilton Day Parade, 4th of July Parade, you'll have somebody who might take that vehicle for the parade. Well, obviously, if they're driving it that day too, and a Newport News police officer asks, where are you going? They say, we're going to the Hilton Parade, then that's understood. But if they're trying to get above and beyond that, as I know there were some concerns about, this language will help to address that. And Mr. Chairman, that is in essence what the bill seeks to achieve, and I'd be happy to answer any questions that members might have.
All right. Anybody on the committee have questions of the patron? All right. Is there anyone, I'm sorry, Senator DeStefano.
I think I'll wait until afterwards. I have
Okay.
a question. I think I know how to solve it, but I think I'm going to wait till after the testimony from everybody on both sides.
All right. Anyone in the audience like to speak in favor of the bill? In opposition to the bill? All right. Step up and state your name and what your opposition is.
Good afternoon. My name is Austin Schwinn, resident of Troutville, Virginia, near Roanoke. I own a surplus Humvee, and a lot of us here have surplus vehicles. I use my vehicle every day. I take it to work. I do commercial deliveries with it because I own my own business. The vehicle has passed Virginia safety inspection. It is currently registered. And there's a lot of confusion about this bill and exactly what it does. One of them is exactly what is being defined at the very top when it's talking about military surplus motor vehicles. That definition is one thing I take issue with because it is a very broad definition that essentially, I mean, there are Chevy pickup trucks essentially that are surplus military vehicles. And by this bill, they would be subject to basically you can't drive it unless it's for very, very strict reasons. There are Dodge pickup trucks that are the same. And these are vehicles that pass Virginia state inspection with really no issues whatsoever. So at the very outset, the definition is something that I disagree with. There is, I
So
also,
before you go any further, let me just kind of, the way you're explaining it to me is you have one that you register normally and you inspect it and you drive it.
yes, sir.
That would be no different than a vehicle that could be registered as an antique vehicle that you register every day and drive it.
Correct.
And I just, I'm not sure if the military surplus language would be applicable to what you're doing. I see the state police jumping up, so I think he might be able to answer that a little bit better than I can, but I just want to make sure that I understand that you have purchased the vehicle, you use it every day, you register it and you inspect it, and it's used as a normally used vehicle.
That's correct.
Okay,
Practically a pickup truck.
all right. Well, I understand, but even if I have an antique vehicle and I register it as normal, it's registered and it's operated as a normal vehicle, it's until I register it as an antique that it becomes an antique vehicle. So if he's not registering it as a military surplus, I don't think he falls under this section, but I'll let you answer that. You're the state police. Okay.
All right, Mr. Chairman, Ron Maxey, Virginia State Police. Through the past year, this issue has come up, brought to our attention by Delegate Yancey. We've looked into this. We have found a lot of information on these vehicles, and some of them have actually been improperly inspected and passed this state safety inspection. I'll allow DMV to speak to the fact on the actual registration of these vehicles, but obviously errors can be made by the one inspecting or registering. With these vehicles, they should not be passing a state inspection. They were never designed to be compliant with federal motor vehicle safety standards. That does not say that they aren't a few that are out there that inspectors did not act correctly, but that information has been passed out to inspection stations. This
Because
bill,
of the vehicle height and.
no, because the federal government did not design these for on-road purposes. We knew this was an issue. This came up last year with Senator Ruff, I believe. And we had to come up with some caveat that would allow the ones that do have these vehicles to at least do something with them. Because the problem that we face right now is this vehicle will not pass a Virginia state safety inspection from this point forward. The registration process I'll allow to DMV as to how those are registered.
Senator Steph, hold on. Ron.
Ron.
I think you might want to stick around.
Just for one or two questions, Mr. Chairman, if I may. Mr. Maxwell, quick question for you. Okay, so I come out of Navy Special Warfare. They surplus their vehicles at 3 to 5 years with 50,000 miles on them. Now, keep in mind, these vehicles are Chevy trucks that are 4x4. They're Humvees. And they would pass a safety inspection. There's no problem with these passing a Virginia safety inspection because they would pass them, and they do today. So what we're trying to say is if it's a vehicle that's not antique, it's not a deuce and a half or a 5-ton, it's under 5,000 pounds, or I think the limit's to 7,500 pounds. So it's something that would be able to be registered as a vehicle because it was truly designed for the road. This being like a Chevy truck, or they have the big Ford F-350s and F-550s. Okay, so those are designed for our roads. they also sell them with about 50,000 miles on them, and they surplus them. If you could get that registered and put a DMV plate on it, I mean, a Virginia plate, and you could have it pass a safety inspection, because they truly would pass a safety inspection. They're made by Ford or Chevy, or they would truly pass the safety inspection without a problem. Would that fall under this area? That would not fall under this, correct? This is primarily for, I'm assuming it's for wheeled, not tracked vehicles.
Well, let me just interject here. The definition says multi-purpose or tactical vehicle that was manufactured by or under the direction of the United States Armed Forces for off-road use, subsequently authorized for sale to civilians.
Mr. Chairman, that would be a Humvee that's sold to everybody. Those were manufactured for off-road use, specifically for the military, and even the old Willys Jeeps, they were originally designed for the military. So on something like that, they would pass safety inspection.
I don't think the old Willys Jeeps did, but.
Well, they don't anymore, but they did then.
No, and not to interrupt, Mr. Chairman, Senator DeSteff, the issue here is that as we've researched this and spoken with the federal government on how these are being sold to the public, the bill of sale on these, every one of them is to be stamped for on-road purposes or some variants of that to make the buyer aware that this vehicle is for off-road purposes for all intents. Depending on where you register this, many of these vehicles are initially titled in a state that does not look as closely. A lot of these come from the exact same states. I won't name, but it's obvious where they go to get these titles. They will come back, present a title, and a lot of times you have a clerk, and again, I will yield to DMV, that's basing information off of that title. This is also how, through the inspection process, some of these have come to be inspected by an inspector who is not following regulations correctly. But the reason these are stamped for off-road purposes is the manufacturer or the federal government, all they have to do is certify that this vehicle does meet federal motor vehicle safety standards, and then that certification would meet our standard and could be subject to a Virginia state inspection. The federal government is telling you when you sell them that it does not meet this standard and they will not certify this, and that's why they stamp the bill of sale to that effect.
But what we're talking about, though, if I may, Mr. Chairman, we're specifically talking about those which are stamped not for on-road usage. There are some that they sell that were designed, were configured, and truly are for on-road usage. So we're specifically saying those that are stamped not for on-road usage. Those are the ones that we're talking about fall under this. The other ones that don't have that stamp on the title are good to go, right?
Correct. As long as the government says that vehicle was not designed for off-road purposes, if that vehicle was compliant with federal motor vehicle safety standards, it's eligible for a Virginia state inspection. Correct.
Okay, got it. So now we've categorized this down to in our purpose, and I'm not sure if tactical vehicle is tactical tracked or tactical wheeled. I'm assuming it covers just wheeled vehicles, because I wouldn't want a tracked vehicle on my road. But so we're only talking about those that are stamped not for on-road usage, correct?
On the original bill of sale, yes, sir.
Correct. Okay, got it. Because I believe most of the 350s, 550s, and the other ones that we used to sell were truly manufactured for road usage, and I don't believe that they were ever stamped not for on-road usage.
Well, and again, through our conversations with the government, they said when these are sold, and I believe it's two companies that primarily do sell these to the public, they say they should not leave without that stamp, that if it does leave without that stamp, it would be an error. So as long as the owner can bring the bill of sale and the bill of sale does not indicate that vehicle was originally designed for off-road purposes and it's compliant in every other way with federal motor vehicle safety standards, then it would be eligible for an inspection, yes.
Can I respond to this?
Sure. Yep. We cut you off, so we're going to let you continue.
There's a lot of confusion about this, and he's saying the federal government determined these are not suitable for road use. There's a lot of controversy about that, and it's not consistent. First and foremost, the federal code that talks about the FMVSS specifically says military vehicles don't have to abide by that. And the reason is because the military actually has their own military standard for safety, and that is in one of the amendments that I proposed. This is Mil Standard 1180B. And the purpose of this, on the next page, it says Section A, or Section B, all of these should meet the FMVSS. And just above that in section A is unless it contradicts the mission requirements of the vehicle that's being made. Also in this document, it talks about what the definitions are of vehicles. And in the amendment that I offered to Senator Newman, the definition was made a little more clear, talking about multipurpose or tactical wheeled vehicles, as you alluded to. And it even kind of cites this military standard about what that definition is or is not. And inside this definition, it specifically talks about how these vehicles are supposed to go on public highways at normal highway speeds. So the contention that they are designed for off-road use is not true, because all of the contracts for the Humvee, for example, required that it be designed for road use. And in fact, I have a letter here that I have supplied to the DMV before, because I have gone through this fight with them 14 months ago, and they tried the same arguments. This is a letter right here where the AM General admits that the Humvee is designed for 60% road use. And this is a letter from the National Highway Traffic Safety Administration telling them that under federal code, it is defined as a motor vehicle because it is designed for road use. There are two of those letters related to that. So first, the contention that they are not designed for road use is patently false, and there's two sources that are cited for that. One is the federal government. What that usually means is the DLA, that's the Defense Logistics Agency. On the vehicles that come from the Army, the Air Force, the Reserve Corps, and places like that, the DLA has oversight over that. It's hard to know exactly where they found the stamp to put off-road use only, because off-road use only is only on, as far as I know, some of the surplus Humvees. If it came from the Marine Corps, it is not under the jurisdiction of the DLA, and therefore it does not say off-road use only. So there are plenty of vehicles that came from GovPlanet or Gov Liquidation that never said off-road use only. Mine is one of them. And before I bought it, I called the DMV and asked for their definitions of off-road vehicles and did all the due diligence I possibly could to make sure I would be okay with this purchase. So
I had a quick question for you, Mr. Chairman, if I may. So I didn't get your name, I'm sorry.
Austin Schwind.
Austin Schwind. So, Mr. Schwind, I think we may have a solution if we can get everybody to agree to it. If we strike out line 441 through 446, that would take away the provision on that. So it would be if all of your vehicles are already currently registered and pass a safety inspection, and I'd like to make sure the state police have a chance to look at this. Line 441 through 446, if we strike that out, since all of your vehicles already are registered and pass a safety inspection, then we wouldn't have that issue.
So essentially you were talking about grandfathering in vehicles?
No, I'm talking about striking out, here.
Well, it sounds like that essentially grandfathers in.
So what it does is any vehicle right now that's currently registered and has been inspected prior to the passage of this law would be, in effect, able to operate and register and be inspected again. But I think the problem will arise when you go back to have it re-inspected, because inspection stations don't always do exactly the way that the manual instructs them to do. But I think you're probably going to find out, even without this law, when you go back to inspect this vehicle, if it's something that they've been letting slip through the crack, that you're not going to get an inspection any longer.
I would love to hear the technical reasons for why they won't, because before I bought it, I went through the inspection manual line by line to make sure that it would. And the only things I had to modify on my vehicle is add a rear license plate light, and I added reverse lights, but apparently that wasn't necessary since it wasn't factory standard. Other than that, it passed inspection just fine. So I'm not sure which parts they're saying is it will fail inspection, absolutely. And I don't think just basically grandfathering the ones in that are currently registered is, it would work for me, but for the future of this, I mean, does have big implications, because it's whether or not people will buy and sell surplus military vehicles. So the federal government does have an interest in being able to sell these vehicles in the future. And if nobody can use them, then they'll be scrapped like they have been in the past.
All right. Senator McClellan, I think you had a question.
Yeah, I just want to make sure I'm understanding the definition, because based on Senator DeSteff's earlier comments and based on how the language is written, I'm now a little bit confused. As I understand the way that we've defined this, it doesn't really matter what the vehicle was designed for. It only matters whether it was manufactured by or under the direction of the U.S. Armed Services for off-road use and subsequently authorized for sale to civilians. So the issue is not what was it designed for. The issue is, was it manufactured by or under the direction of the military, and one of its uses was off-road. Am I reading that correctly? And is that the intent, or is the intent to tie this definition to what it was designed to do?
I'll have to defer to council on that one.
Okay.
Am I allowed to respond?
Let council.
Thank you, Mr. Chairman. Senator McClellan, I'm not sure I entirely understand your question, but I think your interpretation of the definition is correct. I would just add to that it would have to be a vehicle, a multi-purpose or tactical vehicle. That would be the only additional, because that's the first line on line 175.
Right.
The vehicle has to be a multi-purpose or tactical vehicle manufactured by United States Armed Forces for off-road use and subsequently authorized for sale to civilians.
Follow-up question.
Senator McClellan.
As I understand the concerns inherent in the discussion that we're having, is your view is if these vehicles were designed to be on the road, then they should pass the inspection and you should be able to drive them and get registered. But the way we've defined military surplus vehicles, I'm not sure the trigger is was it designed to be on the road or not. The trigger is who manufactured it and can it go off-road. And so my concern is that the way you've defined military surplus motor vehicle in this substitute might not be capturing your actual intent as I understand the bill.
Well, to kind of, just for discussion purposes, when the military, my understanding, if they go for a Ford or a Humvee, whatever, the manufacturer manufactures those to the standard that they use those for, not necessarily what a on-road use would be for.
Right.
And I think that's part of what the definition is trying to say, is that these were never manufactured to be operated on the highway. They were manufactured to be used off-road. Which I'm sure the military have some that are already manufactured to use for highway use.
Okay.
Mr. Chairman, I'd
Like,
like to, if possible, let council chime in. I think she's got this thing solved, and if it can be registered and pass safety inspection. So I'll.
Mr. Chairman, I would like to clarify a little bit with this discussion. This section would apply when the military surplus vehicle has been registered pursuant to this section. It would not automatically apply to all vehicles that would fall into this definition. When you look at the language of the section, we say this section in pretty much every sentence because it's if a vehicle is registered pursuant to this section. And the first section says that Section A says that the commissioners issuing these registration cards upon receipt of an application and evidence from the applicant. So someone would need to apply for this. This would not apply if the vehicle could be registered and inspected pursuant to another section of the code.
All right. Senator Wexton, we got about 5 minutes, so we got to move.
Council kind of answered my question, which was if we're talking about somebody's got like a Humvee that they use for their personal vehicle, it's their only car, and it otherwise passes inspection, it's got all the right safety stuff on it, would they then have to register it under this section?
No.
Okay. So.
Same as if you had an antique vehicle, you wouldn't be registering it as a personal vehicle that you drive every day.
So based on that, who's going to make that determination of whether it falls into, which category it falls into? Because it sounds like there's some confusion about whether your average Humvee is going to fall in that category or not.
Captain Maxey, you want to?
Mr. Chairman, Senator Wexton, correct, and council's correct in this, of course, being an attorney, she would be. This is specific to the instance that we're addressing here. The gentleman's situation here would be different than what's being addressed in this bill. He would have to take up the issue of inspection, which will obviously be coming to his attention very shortly. So, but that would be outside the scope of this actual bill as to what they're addressing here.
All right.
Thank you.
Okay, anyone else in the audience like to speak? Real quick, come on up. So, well, we will. Just let these.
How you doing today?
Good, how are you?
I'm from Amherst County, Virginia, and I'm a Desert Storm vet, and I've been in these vehicles for 14 years. And there's nothing unsafe about them, no more than that Senate 3 outside that's an H2. They're all safe. I just don't know, they still don't explain, other than they're off-road, what's unsafe about them. They pass the inspections. Now, if there's a problem with these people going around the corner to pass them, then they need to look at the inspectors, not the vehicle. The vehicle's already passed inspection. And if you have that, which I have 2 of them that I have tagged and titled, that there's no problem, you know, taking them and getting them, going by the law, and if they're inspected and they pass, they should be safe enough.
And that's what we were explaining earlier. If those vehicles, those 2 vehicles that you say you have,
right,
have already been inspected and proven that they have all the safety whistles, you're not registering them under this section. You're registering them under a normal section of law.
Personal use.
Personal
right.
use. So it doesn't apply to you. This is only for someone who's buying it for the purposes of off-road use. And they would be able to operate it to and from an event like a parade or to wherever 125 miles is from their residence, to a farm or whatever. That does not apply to you. Same applies to an antique vehicle. If you have a vehicle that's over 25 years old and you want to use it every day, you can register it as long as it meets all the safety standards. And until you decide that you want to just use it as an antique vehicle, then you're restricted. Once you buy that one-time $50 tag, you're restricted on how you can use that vehicle.
Right, that's correct.
So it's the same principle.
What is, also, what is the where you can occasionally drive? Nothing, when you get pulled over, I'm on an occasional drive. Well, when I'm pulled over 3 days from now, I'm on an occasional drive.
That's the reason for the language that says the officer may stop and inquire where he's driving from and where he's going. That way you can effectively enforce the occasional drive.
Right, because I have my 3rd one still sitting on my trailer that I got to change an injection pump on it, and I got to get that titled. So
if you meet all the safety standards,
so if it
you can register it just like you would.
Okay.
Yep.
All right. Thank you very much.
Okay.
Have a good day.
Mr. Chairman, Senators, thank you for your time. I think there are a couple of points that are being missed here. You're stating that if the vehicle has already passed an inspection, is already registered, then this bill would not apply. However, there is specific language in here that says the department shall cancel the registrations of vehicles owned by persons that prior to January 1, 2019 do not re-register such vehicle with the department. So there is specifically a cancellation of any grandfather clause here.
That was the one we're debating on the amendment as to whether it was under this provision of this section to strike out.
Okay. Additionally, so the vehicle I have probably north of $35,000 invested in one of these vehicles. It is gloss black. It has hard doors, hard top. It has civilian wheels and tires. It is in all purposes indistinguishable from the civilian version of this truck called the H1. There is nothing in this bill that addresses that vehicle, even though that vehicle is mechanically identical to the military vehicle. Same engine, same drivetrain, same chassis, same body for the most part, same safety features, 3-point seat belts, the whole 9 yards. So I think there is a civilian counterpart to the vehicle that most of us are addressing here. I think it's important to consider that fact. It is hard to argue that these vehicles were manufactured for off-road use, given that the same manufacturer who manufactured them for the U.S. government also manufactured a version that is outside of the scope of this bill that is effectively an identical vehicle. That concerns me greatly. From the language of occasional use, if we assume that all owners of Humvees in particular must comply with this, I place a great premium on being a law-abiding citizen. Under the language presented here, if I take my vehicle to the store for groceries, that is not recreational use. I am now committing a crime. I would hope that the committee weighs personal freedoms also when they're evaluating these kinds of bills. If I wanted to drive a vehicle, a Humvee, to work on occasion because I have a coworker who is in out of town who is interested in seeing that, I'd be committing a crime. So
If you register it as a multi-purpose.
correct. As this bill is written, all vehicles, all Humvees, former military vehicles, would need to be registered as such, would need to bear that plate. So in that regard, I couldn't escape committing a criminal act through occasional use that isn't necessarily pleasure driving, going to the store, driving it to work so that a coworker could look at it, something along those lines.
Mr. Chairman?
I think
I hate to interrupt you, but if I can push forth this amendment, if you can register it today and you can pass safety inspection, which allows you to register it today.
Sure.
If we delete line 441 through 446, which I'd like to do in the amendment, then as long as you can pass the safety inspection and you can register it, which you can do, as long as you don't put in for this specialty plate, you're good to go. You have no reason to do anything but. It's got a normal Virginia license on it.
Yes,
You've got a safety inspection, you're good to go, no issues. If we delete this section, then you're not forced to do it. And for any vehicle in the future, if you buy a military surplus vehicle, you pass a safety inspection and you register it with standard Virginia tags, you're good to go. The only time that this would apply is if you wanted to put specialty license plates on it and use it specifically for off-road use. Then the restrictions of this bill would apply. Outside of that, the restrictions of this bill would not apply at all. So I think we resolved everybody's issue on this.
So is that amendment?
That's my amendment.
All right, there's an amendment and a second. All in favor say aye.
Aye.
All right, that language struck. You have no worries as long as you meet the safety inspections and register it as a normal vehicle.
Yes, Mr. Chairman.
Okay.
Thank you.
All right, next. Real quickly.
Good afternoon, Senators, and thank you for your time. My name is Daniel Urban. I'm an owner of a 1989 AM General Humvee, model M998. I wish to support the amendment proposed by Mr. DeStef.
It's there.
Okay. While I have many concerns about the bill in its entirety, I have chosen to read the statement from fellow Virginia Humvee owner Shannon Johnson, who could not attend today. I, Shannon Johnson, wish to express my personal loss if House Bill 1323 passes. I'm the owner of 2 former military Humvees. Most importantly, I am the mother of a 3-year-old little girl. In 8 short months of having a Humvee, we, as a family, have embarked on unforgettable adventures that I hope do not end because of this bill. We climbed a mountain in Syria, Virginia, searched for wild horses on the beaches of the Outer Banks. We watched fireworks from the tailgate on the 4th of July, and the Humvee carried our Christmas tree home in December. Shannon would like to thank Mr. DeStef for his amendment and supports that. Thank you.
All right, anyone else? All right, just a moment. There's a technical amendment to go along with the amendment we struck out that we need to add to the substitute.
Thank you, Mr. Chairman. On line 434 of the substitute, after motor vehicle, insert registered pursuant to this section.
All right. Is there a motion on the? It's been moved and seconded. We adopt the technical amendment. All in favor say aye. Aye. All opposed. All right, so now what we have is a bill in a form of substitute that has been amended, that anyone who currently operates and has had registered or inspected, that operates the vehicle as a normally operated vehicle is covered. They're not under this bill. But if you purchase one specifically for off-road use, a multi-purpose section of this bill, and you do the one-time $100 registration fee, then you're prohibited to use it for normal use, just as you would with an antique tag. So as long as everyone's clear as to what the bill does now, we're ready for a motion. All right, there's a motion. Is there a second? There's a motion and a second to report House Bill 1323 as amended. All in favor, vote aye.
Looks like you get to explain this.
11 ayes, 2 nays.
I think I can. All right, the bill reports, I think 12 to 2.
Thank you, Mr.
11
Chairman.
to 2.
Mr. Chairman, members, thank
All
you.
right. Okay, that completes our docket. I appreciate everybody's attention, and and those of you, hopefully tomorrow, you can join us for dinner. You should have received an invitation. Hope to see everybody there. Thank you. We're adjourned.